Hey, folks, time to revisit the Laura Owens case, or in this case, David S. Gingras' conduct towards the disciplinary judge and his attempt to subpoena both Judge Mada and her father. And now, Harry Howe, Judge Mada's father, has made a reply to Gingera's response, which we covered in the previous stream. But not going to, as you see, this is a video because not enough. When I stream, I try to make it at least an hour. This is not for an hour. It's considerably shorter than that. So what we're going to do is that we're going to read it. I'm going to comment on it. And then we will make, so we can make it to the next time Mr. Gingras does something stupid, which is quite often, apparently. Welcome to the show. So here it is. Oh, hold on. Oh, no. Let's get that out of the way so that we can actually see what's written here. In the matter of a member of the State Bar of Arizona, David S. Gingras, bar number 021097. This reply is filed by Harry Howe pro per, hereinafter undersigned a third party to the ongoing disciplinary action. Respondent filed the pleading entitled Motion to Compel, second, on March 23rd. Then on March 24th, respondent filed a pleading entitled Response to Motion to Quash, filed by Harry Howe, Julie A. Mada. The response to motion to quash refers to the motion to compel, second, which makes clear and concise reply somewhat difficult. Most judges prefer that a motion deal with one discrete subject, meaning one thing at the time, which David S. Gingras is mentally unable to do. He wants to confuse everything to make things harder for everybody because then he can stall things. Well, I don't think he actually knows he's stalling things. He thinks that makes him intellectually superior. Mr. Gingras, if you ever come across this, it makes you look like a fucking moron. However, in this reply, undersigned will address the response to motion to quash, as it is dispositive of the previously filed motion to compel. Respondent does not even address the indisputable fact that his subpoena, Dukas Tecum, was invalid and unenforceable. Indeed, he appears to be trying to compel enforcement of a subpoena that is clearly defective without addressing the objection. He has put the cart before the horse. As stated in undersigned's objection to and motion to quash subpoena, your undersigned was served with a subpoena on Monday, March 9th, 2026, at approximately 8:30 p.m. A true and correct copy of that subpoena was attached to the original objection. The subpoena called for your undersigned to appear to testify and produce documents on the same date, March 9th, with no time specified for the appearance. It should be pointed out, folks, by the way, if you, address to Gingras, it's a more or less a PO box. So, no, it's not his address. There's no doxing going on here. It should be pointed out, I should have kept reading. It should be pointed out that this address is a UPS post office box. There will be absolutely no way for undersigned to have appeared on March 9 at a time unspecified and at a no doubt closed UPS mailing store to testify or produce documents. Yeah, yeah. What, you're going to squeeze everybody in there in box? Mr. Gingras, you have to think outside of the box. Arizona Civil Rule 30B, which is incorporated into the disciplinary rules, requires a party or his her lawyer to give 10 business days advance notice before a deposition may be held. That indisputably did not occur here. More importantly, Rule 47H3 of the Rules of the Supreme Court of Arizona provides that a non-party may file an objection to the subpoena. No limitation, be it relevance, overly broad, insufficient time to comply, or otherwise, is set forth in Rule 47. Any objection is therefore allowable. Rule 45, Arizona Rules of Civil Procedure, which of course is not incorporated into the disciplinary rules, can serve as an illustration. Rule 45E2 provides that the court must quash a subpoena if it fails to allow a reasonable time to comply. It certainly goes without saying that a subpoena served at 8:30 p.m. on March 9th for appearance to testify and produce documents on the same date, times not specified, at a commercial P.O. box establishment fails to allow a reasonable time to comply. There is no need to belabor this point. The subpoena served upon undersigned was facially defective, incapable of being complied with, and must be quashed. Respondent had seen fit to file a motion to compel a clearly deficient and improper subpoena. Should the presiding disciplinary judge determine that a response to the prematurely filed motion to compel is necessary, the undersigned respectfully request the court provide undersigned an additional 5 business days following the ruling on motion to quash to respond. Further, in an abundance of caution, undersigned points out that the factual basis and analysis of respondent on the ability of a non-party to object to the relevance of requested documents is flawed. Factually, respondent's motion is improperly based upon hearsay and out-of-court statements without any foundation. Respondent's legal analysis cites only Blair v. U.S. and Samishina versus Yamashiro in support of his position. Neither case is apposite, as both cases dealt with the ability of a witness who is testifying to raise relevance objections while testifying. No such prohibition exists against objection to the production of irrelevant documents by a non-party. A non-party has the ability to raise any objection, including relevance to production of documents by subpoena. And he cites all the rules here. Respondent would have this court believe that he could subpoena undersigned's family photo albums, utility bills, vehicle titles, or the like without any showing of relevance, and undersigned would have absolutely no ability or right to object. That is silly. During sworn testimony or a trial, presumably attorneys are present who will make appropriate relevance objections. But in the subpoena for documents of a non-party, no such guardrail exists to protect the non-party, and thus neither the rules nor case law prevents a relevance objection. Therefore, undersigned respectfully moves this court for an order quashing the subpoena served on March 9th. In the event the subpoena is not quashed, undersigned respectfully moves this court for an order that he have 5 business days from the date of the order to serve a supplemental response to the motion to compel, fully researched and analyzed. Respectfully submitted this 25th day of March 2026. Harry L. Howe, pro per. And addressed then to the Senior Bar Counsel for State Bar of Arizona. And he's queuing in the Arizona Attorney General. Now, why would he do that? that is interesting here. Because Arizona Attorney General is the party who is bringing charges against Laura Owens. Among other things. Or, well, it's in the county, yes, it is the county's prosecutor who does this. And as you can see here, those are addressed as well. So now he's queuing in the people who are prosecuting Laura Owens. That is interesting. I would assume it is, because in this case against Laura Owens, he might be forced to testify. And his actions in this might be relevant to them. All right, folks. That was Mr. Howe's reply, which is a great reply. Very, very good. I mean, puts Mr. Gingras in his place. Now, will this help? No, because David as Gingras, he doesn't care about law, about rules. He just wants to, as him and Laura Owens are two peas in a pod. They are punishing people they believe wrongs them by making them take time out of their lives to file responses to stupid filings by David Gingras. So there will be a continuation of this. There will be more. And you can be damn sure that I will cover it every time. Thank you for listening in. You all have a good day. And I will see you in the next stream or video. Bye-bye.